democracy. Thank you very, very much, Paul. It's a privilege to be here and speak to you again. I'm here to speak about freedom of speech, and I'm here at a time when you begin to fear whether freedom of speech can any longer exist. But before I do, I think for two very good reasons, we should begin by contemplating the alternative to freedom of speech, contemplating what the laws of Canada have done and are doing to people today, and we should contemplate it in the way that it makes the most sense. Because, of course, the alternative to freedom of speech, or to speech itself, is silence. And there are two people in jail in this country at this very moment, not for anything they did, but for what they said and for what they believed. Those people are Don Andrews and John Ross Taylor. And for those two reasons, and with an explanation that will follow, I would ask you to do something which really does focus the mind, and that is for us to sit here and think about those two people and think about freedom of speech for exactly 1 minute in silence. That was just one moment, 1 minute of silence. John Ross Taylor will be in jail for thousands of minutes, hundreds of hours, dozens of weeks, and several months, because he tape recorded a message on a telephone answering machine and gave out little slips of paper to people saying, if you would like a message, phone this number. He's now 80 years of age, and he's in jail today, and he will be in jail tonight, and he will be in jail tomorrow for that. And Brian Mulroney wanders the streets of this country, a free man saying things that are probably 10 times more destructive to human life and human dignity than anything John Ross Taylor could ever have said or done. And Mr. Andrews is in jail for publishing his political opinions. Now, of course, they wouldn't be in jail if they were communists, because we all believe in the rights of communists. They were perhaps deemed to be racists. They were perhaps deemed to be Nazis or National Socialists. But if we're not looking at the content of what people say and deciding we like your opinion and we don't like your opinion, if we're not really doing that, why are they in jail? The answer is that's exactly what the Government of Canada has authorized through the Human Rights Commission legislation and through the law of the Criminal Code, sections that in fact prohibit what is called hate and put the burden of proving truth upon the accused. And if the allegation of hate involves history, how do you prove the truth in history with properly admissible evidence? How do you prove that Napoleon won the Battle of Waterloo without hearsay? How do you prove that the Second World War was fought for some motive other than freedom and democracy if you can't use hearsay? What it boils down to is if I don't like your opinion, you have no right to speak. And it's being used today against a few people whose opinions are largely unpopular. One wonders why it's being used against those people if it isn't the fear of some truth they might be saying. Because don't we trust people's intelligence to decide what is right and what is wrong, what is true and what is false, in a so-called democracy? After all, don't we premise democracy upon the fundamental principle that the average human being has the right to choose the government and the principles and the beliefs that they wish to choose? If we really do practice and believe in this theory of democracy, then we must allow the expression of all points of view that do not advocate violence. If we do not believe in the value and the intelligence of the average person to make those decisions, why do we allow people to vote? Do we only allow people to vote for approved candidates and approved parties? In which case, do they have any real vote at all? If the state said, in effect, very clearly, if we don't like your opinions, you will not have the right to speak, most people would be outraged. But they say it in a subtle, convoluted, and diabolically twisted way so that nobody realizes what is really being said. It's really basically arbitrary and offensive. In the cases of James Keekstra and John Ross Taylor and Ernst Zundel, Malcolm Ross, in many ways, that's exactly what the state has done. It has said, I don't like your opinions, therefore you have no right to speak. In communist countries in Stalinist times, and maybe even now, where all the Stalinists call themselves social democrats today, the media campaign always precedes the public trial. In the cases I've mentioned, Keekstra, Zundel, Ross, Taylor, the media campaign was massive, consistent, and effective. It vilified, exaggerated, and damaged and destroyed the reputations of these people long before the public trial ever began. And this, of course, has enormous impact on the impartiality of any potential trial. It also has impact on the court that might review the verdict from the point of view of public perception. And I don't think for a moment that judges are immune from public perception. It puts enormous pressure on juries. For example, in the Finta case, where in fact it was not exactly the same issue, but a similar issue, juries were threatened. I, of course, was also threatened. Everybody who resisted the suggestion that there had to be a conviction, or who had any judicious power in that respect, was threatened verbally over the telephone and any other way that was possible. The public was pressured, first of all, as I say, through the massive media campaign, so that if anybody questioned whether this was the right thing to do, they were immediately accused of having the same views and therefore being as guilty as the witch they wanted to burn. And thirdly, lawyers are pressured. Particularly lawyers, you know, we all hate lawyers, unless we're lawyers, or law societies. And if we're lawyers, we often hate law societies, but we never say so. We wouldn't dare. And I suppose there's a legitimate place for law societies, but certainly there is in terms of regulating the conduct of lawyers in matters of trust, such as the holding of other people's money. But I question whether law societies have much of a purpose in controlling what lawyers say. But in any event, that seems to be the belief of some people. And one of the methods of intimidating lawyers is something I'll describe immediately, and that is that at meetings like this, law firms representing really basically predatory pressure groups send surreptitious spies to tape record the message, edit it, and say that their tape recorder was defective so they couldn't get the whole message, and then send parts of the message to the law society as a complaint that something said by the speaker was derogatory either to the legal profession or to the judiciary. And that is exactly what was done when I spoke at a meeting to try and raise some money to give Imre Finta a place to live when the CTV took away his house. That's not, of course, the only form of pressure, because they can compound these complaints until eventually they become almost unbearable. And that, in effect, is what has happened in my career since about 1984, when I began to act for James Keegstra. So all these forms of pressure are applied basically to prevent justice and fairness, in my opinion. So it's become, in effect, a popularity contest of opinions, and the judiciary are caught in the middle. It's an unpleasant position to be in, but the real reason they're caught in the middle is because the Charter has given the judiciary the power to define what is demonstrably justifiable in a free and democratic society. Now, judges start out as ordinary human beings, you know. They start out usually as lawyers, and they often have some sort of political influence. They often are political candidates, sometimes defeated for political parties. And they get appointed to the position of a judge, and then God knows what happens in terms of how they get promoted thereafter, but I suspect, like in most human affairs, there's an element of politics even in that. But we're not supposed to speculate about that. We're not entitled to criticize the judiciary in the way we would a parliamentarian. But one thing I think it's fair to say is that these men who become judges are not divinely ordained as such. They are not created by God any more than I am. And they are not created with any greater intelligence than other people. They're very learned in the law, and they're to be respected for their legal opinions, perhaps. But when it comes to social opinions, I question whether they're any more entitled to exercise arbitrary power than anybody else. If, for instance, we were to say, let's pick 9 people from this room who will decide what is demonstrably justifiable in a free and democratic society. And we won't have, the rest of us, any right to say about that. I would think most people would perceive that as being very dangerous and arbitrary power. That's probably why we have a certain faith in democracy. But there are 9 judges in the Supreme Court of Canada who are endowed with that power. They didn't ask for it, in fairness. They didn't ask for it for themselves. I think a rather irresponsible Parliament gave it to them. And it gave it to them in a way that could never be taken away. And it gave it to them in a way that could never be reviewed by any other authority. So what, in effect, it becomes the ultimate determination of what is a lawful law or an unlawful law. Because you see, these rights and freedoms that are given to us in the Constitution, freedom of speech, freedom of assembly, freedom of religion, freedom of conscience, freedom of expression, all those freedoms are, under Section 1, subject to such reasonable limits as are demonstrably justifiable in a free and democratic society. So what does that mean? Well, it means whatever the judges of the Supreme Court of Canada say it means. They decide what is demonstrably justifiable in a free and democratic society. I maintain that in a free and democratic society, it is the people who must make that decision. People who then elect members of a parliamentary body, like the House of Commons, to decide that question. Because no one can be trusted to know what is good and demonstrably justifiable in a free and democratic society for everybody else. But that appears to be the conundrum into which the judiciary have been placed by the Constitution, and until recently it was entirely clear to most people that that was a dangerous thing to do. It's becoming more clear now, I believe. Now, in 1982, when the Constitution was being proposed, I was traveling throughout Western Canada speaking out against this proposal, specifically that provision, Section 1, because in my opinion it was very similar to the limits on the freedoms that existed in the Soviet Constitution in the respect of being a discretionary limit. A discretionary limit that can be and often is arbitrarily applied. For example, you could say that all those freedoms exist subject to such reasonable limits as are justifiably necessary for the preservation of the socialist order. What it means then is we give you all these freedoms and we take them all away immediately. We take them all away if we don't like the way you're using them. And I think that's what it's boiled down to. in terms of the Keekstra judgment, in terms of the judgment of the courts in Taylor and Andrews and Smith, and as it will probably be the case, and we don't know what will be the outcome, and it could be different because two of the majority judgment in Keekstra are no longer there, and Mr. Justice Stevenson from the Alberta Court of Appeal is now in one of those vacancies, and he held that the law in Keekstra was contrary to the Constitution. So we don't know the outcome in terms of the Zundel appeal, but I'm questioning here whether in a free and democratic society the power to define what is a demonstrably justifiable limit should rest in the hands of unelected officials at all, because of the danger that in effect they will apply their own personal judgments on whether they like the speech or they don't like the speech. What it boils down to is a content-based analysis. What do I mean by that? That means that I look at what you say to determine if you should have the right to say it. And in the United States there's been a desire, at least apparent desire, to resist that interpretation. But unfortunately the judiciary of this country have been pushed into the position where they have to interpret this section, Section 1, and they've done it. The majority in the Keekstra case have decided on the basis of content whether the speech should be limited or not, and whether the section that limits it is justified or not. You know, Mr. Keekstra was charged with promoting hatred between 1978 and 82 in his speech in Eckville High School. Just think about that for a moment. How many of you can remember what you said between 1978 and 82 in 1984? And how many of you can with any accuracy say, no, I didn't say that, I said this? When the accusation arises in 1984, how will you know what you said between 1978 and 1982? And if it's been 4 years between those between those 2 years, 78 and 82, if it's in those 4 years, how do you know that the person who says you said it is really accurate? What it becomes is very much like those witch hunt trials in the Soviet Union, where the accusation is never specified until the trial is over, and then the judge decides what the accusation was on the basis of the evidence that he's heard. See, that's what happens. First, the public trial and the public condemnation and the ridicule and the total destruction of your reputation, so that you do not have any credibility by the time you get to trial. And you do not have any public support either, because either the public condemns you, or any individual who has the nerve to question that has said, well, you're just as guilty as he is. And he's a madman and you're crazy too. And that's the way they conduct these trials. That's the way they were conducted in the Soviet Union. I don't think the analogy between what Paul said, the communist loony in the street and the communist loony at the top of some government commission, is all that strained, because you see exactly the same sort of tactics and procedure occurring in reality. Some government bureaucrat or some commissioner presides over a human rights inquiry, for example. He's appointed, not elected, of course. What his training and education are, nobody knows. He's never had to account for it to anybody. You know, in the United States of America, the country we've often thought of in terms of being less free and less responsible, or we've often looked down on the United States. Do you know what Supreme Court judges have to go through before they're entitled to be Supreme Court judges? They have to answer questions on previous decisions, their past life, their political beliefs, their political affiliations, whether their country club had color bars, and whether they've ever smoked marijuana, and 100 other questions. Do you know how many questions a judge in Canada has to answer, but in public at least, before he becomes a judge? Not one. Not one. And it's a very interesting thing. We never get an insight into just how it happens, you know, that this mere mortal gets elevated to the position of being able to define what is demonstrably justifiable in free and democratic society. But at one point, I read an article in which Mr. Justice Corey described the day he became a Supreme Court judge, or at least heard he was to be. He got a phone call from the Prime Minister during, I think, a football game or a hockey game or something. A phone call from Brian Mulroney, and that was it. Not any public inquiry or public hearings to determine, you know, just who is this person, what do they believe. If they're going to be deciding these big and important issues, maybe we should know. Nothing like that. And not that I agree with Alan Fotheringham very often, but recently he made a comment on this rather strange anomaly that here's a judiciary that has really enormous power to define and shape society, as Madam Justice Wilson commented about her role, that she was here to shape society. This enormous power is never questioned prior to the time the person becomes a judge. And surely this is something that the American system has that might very well be of merit and value to place at least some public scrutiny upon the form of belief that these people have about society. I'm not suggesting that they're going to be any more accountable, but maybe that's not a bad system. But anyway, we don't have that in this country. And that's why we have laws that, in my opinion at least, do not recognize the legitimate right of a free citizen in a democratic society to find out for themselves whether they like or don't like what James Keekstra has to say. Not through the media, but through talking to him. And he should not, nor should I, nor should anyone, live in fear of some dire consequences for what they say, unless they advocate violence or crime or participate in some direct attack on the rights and freedoms of some other person, by more than mere words. Short of that, why do we need protection by the state? You know, if we needed protection by the state from mere words, I'd be dead. Because I haven't had any protection by the state from mere words. I've been threatened with death hundreds of times. I've been called everything in the book by the media, and nobody came to my defense. You know, you're listening to what Mr. Bannerman of CKNW called a perverted monster to 60,000 people. And that, of course, according to the courts up to now, was not anything but fair comment. So it all boils down to who you are and whether they like you, whether or not you have freedom to have a reputation or not. It seems as if we protect groups in society because we have what are called human rights, but we do not protect individuals because basically individuals seem to have less and less rights. Unless you're a member of a group identified by race, religion, or ethnic origin, it seems as if you cannot really have rights. Now that's a very consistent thing with the whole idea of Marxism, because you have class rights but no individual rights. Now it's maybe more than just a coincidence that our whole society has deprived or minimized and reduced the concept of individual freedom, maximized, increased, and interpreted even larger the concept of group rights known as human rights. There's a great difference at law between human rights and individual rights. I personally believe that every person should have equal individual rights, and groups do not need special protection, that their members as individuals have rights, but there should be no special privileges based upon being a member of a race, religion, or an ethnic origin. So, what has happened in the cases of James Keekstra is that the whole question has now been resolved. And resolved in a way that I think if people could understand it would be very, very shocking. I say that because I was reading the judgment of the majority, and I must say it's a slim majority. And as Paul said, there is hope that change may occur, because of course judges retire and other judges come into their place, and maybe with a 4-3 majority there's a possibility that interpretation might vary the situation. But I want to read you one sentence which proves two things. First of all, it proves that these judgments are written in such convoluted language that the average person is never going to know where the boundaries of freedom of speech lie. And the result of that is that fear will silence more than illegitimate speech, even under these rules. So I say this is written in convoluted language. But I say also that when it's reduced to its simplicity and to its essence, It is the most dangerous statement that I have ever heard that goes contrary to the principles of the presumption of innocence and the necessity for the Crown and the state to prove guilt beyond a reasonable doubt. I will now read you the sentence, and first of all consider whether I said it was convoluted and whether it really is. Consider this. This is the judgment of the majority of the highest court in Canada. Quote, that the legislative line is drawn so as to convict the accused who is negligent or even innocent regarding the accuracy of his or her statements is perfectly acceptable. Obviously some of you understood that. And you didn't. And you know, don't feel badly, because I've asked people this in a couple of places now, and they look at me with a blank stare and they say, what does it mean? Well, I say that it's convoluted, but I also say it's dangerous. Why do I say it's convoluted? Because people don't understand it. What's wrong with that? Well, because if this is to be the law of the land regarding freedom of speech, we all have tongues, right? We all have these things, brains between our ears. And we're all, at some stage or another, going to want to use both. You see? It's not as if it's a driver's license and all, you know, even there it's reduced to simplicity so people know where the rules of the road are. But this is dealing with how you and I will use these and this for the rest of our lives. So do you understand it? Well, I'll tell you, I think I do, but I could be wrong. Now, I'm going to say that's why the convoluted nature of this judgment is entirely unfair and dangerous. Because everybody has to understand these rules of freedom of speech so we don't commit offenses with our opinions and our beliefs. And if the average person cannot understand it, it's a bad, bad judgment for that reason alone. You know, I said once that if I can't explain what I do to the lady who cleans my office, I don't know what it is myself. Because, you know, when you know what you're talking about, you can explain things. And they are not that complicated. The rules on whether we have what freedom of speech we have cannot be complicated, because it's got to be understood by everybody, or else we're going to have innocent people committing crimes with words. Well, all it boils down to, of course, is there's going to be discretionary power to decide who to prosecute, and it'll always be used against those who constitute a threat to the powerful, that's all. The average person doesn't really need to worry about what they say, because no one will ever listen. It's only when a large number of people begin to listen to you that the government, or those in power, will use these laws to get you. And because they're this vague, it won't be very hard. Because a lot of times we have to remember who appoints the judges. Now, I'll explain what I think about it as to why it's dangerous. What it really says, as I understand it, is this. It doesn't matter whether the person honestly believes what they say to be true or are really just negligent about what they say. If the court says it isn't true, the fact that you honestly believed it was is no value at all. You see, that attacks the presumption of innocence. It attacks the right to be free if you are honest in what you say. You're not, you know, you don't have to be a liar. You can be totally honest and say, I believe this or that about X. And if X happens to be a race, religion, or ethnic origin, and though you honestly believe it, makes absolutely no difference. What that boils down to is that honestly held opinions are no defense. It means that innocence, you can, in my view at least, no one should ever be a criminal with an innocent mind. Because mens rea, as I understand it, means guilty mind. And our purpose in criminal law, the moral purpose of it, is to punish those who have guilty minds. And if that isn't the fundamental reason, the moral reason for the law, what is it? Just to punish those who are a nuisance? Or idiots? Or by accident make mistakes? In my opinion, we ought not to punish those in those categories. And if we do, we are going to vilify and criminalize innocent people. And therefore I say, when And this says that the legislative line is drawn so as to convict the accused who is negligent or even innocent, of the inaccuracy of their statement. That's not totally acceptable. That is not justified, in my view. It should never be justified in a free and democratic society to criminalize someone who is innocent or negligent about what they say. And that must be qualified by this, that there's never any need in this law for even the promotion of hatred, the accomplishment of hatred, the advancement of hatred, or any other effect. Only if it is capable and likely to promote hatred, could promote hatred, then an innocent or even negligent statement that might have that effect can make you a criminal. And in my view, that is a statement of principle that is anathema to every fiber of my being as to the morality of the law. It just seems totally, utterly, profoundly wicked to me. Now, what am I supposed to say? That's Mr. Justice Dixon. That's the majority of the Supreme Court of Canada. And that's the law according to which we must live. I'll read you another sentence. And this is, in my opinion, a demonstration of how unfair it is to place these matters in the hands of judges and force judges, in effect, to rule upon these matters. And I must say, in defense of judges, they didn't ask for this duty. It was thrust upon them, but I question the wisdom of the Parliament that did it, and I point to the dangers of the consequences of doing it. Here's a sentence that I'm supposed to understand, and so are you, so we can guide our lives and avoid criminality and understand the moral value and purposes of the law. Here's the sentence. The possibility of illegal police harassment clearly has minimal bearing on the proportionality of hate propaganda legislation to legitimate parliamentary objectives, and hence the argument based on such harassment can be rejected. Do you understand it? Do you know, I don't understand it either. I'm going to tell you honestly, I don't understand it. You know, there's something about intellectual pride. Judges and lawyers seem to think that they and they alone need understand these things. And often, in my opinion, it's like the case of the emperor who pranced around the countryside wearing no clothes, but everybody flattered him on what wonderful clothes he was wearing until a little boy said he has no clothes. And that's what I said in my summation to the jury in the Finta case about the war crimes legislation. I said it's morally absurd. It's so convoluted and twisted that nobody can understand it and when they do, it's absurd. Oh, don't say that. Don't ever say that to the jury. Morality has no place in a jury address. And I was told recently by the prosecutor in his argument before the Court of Appeal the other day, you have no business appealing to a Christian conscience. I said, is that right? I know the Court of Appeal has ruled that you can't have an official Christian position in government. You can't have Christianity preached in the schools. You can't have public prayers. You can't have anything that publicly reflects Christianity. But I hadn't heard yet that it was illegal to appeal to a Christian conscience of a jury in this country. And if so, why are they swearing on a Christian Bible? Maybe we better take that out and have them swear on a rock or their foot. But you know what? I was questioned, and really strenuously questioned, by the Court of Appeal with the implication that, oh, you don't seriously contend that you can appeal to a Christian conscience, do you? To a Christian conscience? And I said, yes, I should think so. You know, you can drive my religion out of the public field, you can condemn it before the Human Rights Commission, but you cannot condemn it in my heart, and you will not tell me that I cannot appeal to the Christian conscience of a jury. If they have no Christian conscience, that's their business. But then they shouldn't be swearing on a Christian Bible, which they all did. Some people find that offensive, and I don't blame you. I mean, I'm not asking you to be a Christian. I'm not saying I'm the world's greatest Christian. I'm not. You know, that's a fact. But I have a right to try. And God damn the Court of Appeal if they tell me I can't. All I can say is that if you could read this 100 pages, it would leave you with either a headache or a state of confusion. And that, to me, is the danger. That is the danger of judges who can interpret the law and in the process make the law by defining what is demonstrably justifiable in a free and democratic society. In my view, at least, judges should not take it upon themselves to impose their personal opinions upon the rest of society unless those judges have been publicly identified with those opinions prior to the time of their approval, and some elected representatives have decided that they should be judges. And I'm suggesting by that that there should be a means of review of the appointment procedure that is both public and democratic. By that I mean that some democratically elected official should be able to vote yes or no on whether this person should or shouldn't be a judge. Very much like the Judicial Committee of the American Congress that decides, House Judiciary Committee, that decides on the appointment of judges. So this power, though, under Section 1 is really enormous. That doesn't mean they can initiate legislation, it's true, but they do decide whether that legislation stands or falls. And they have been doing so, obviously, in the Keekster case on the basis of whether or not they consider the speech legitimate. One of the other things that troubled me about the judgment of the Supreme Court of Canada was that they decided what the facts were in their judgment. Now, that may seem illogical on my part. You might think they should have the right to decide what the facts are. But they were not the jury. They did not hear the evidence, and the jury did not give a reason and a judgment upon the facts. They did not say, we find this to be a fact, or that to be a fact, or this to be a fact. They said, guilty or not guilty, in this case, guilty. That verdict does not indicate what facts they found, and it's speculative as to what facts they found. Okay, so how did the Supreme Court of Canada find out what the facts were? Well, there's two possibilities. They listened to the media, or they read the transcript. Well, the transcript was never filed before the Supreme Court of Canada, so they couldn't have read the transcript. Because, you see, it was a constitutional question, and obviously we didn't file 60 times 22 times 500 pages. They actually received a summary of the facts from the Crown. Well, those facts from the Crown were the students' notes, and the opinions expressed not in all students, because many students contradicted some who gave what the Crown labeled as the facts. They must then have decided that the Crown's version of the facts was the facts. And I question how they could do that, because at least I put before them the suggestion that the accused testified and denied many of those statements. And as I said earlier, how could you know and be accurate in your description of denying many if it was 4 years ago and over a period of 4 years? In any event, how did the Supreme Court of Canada decide what the facts were and that the accused's speech was so vile? As I say, there's only two ways. They were there and heard the evidence, read the evidence, which they didn't, or they saw the media and decided that way. They saw the Crown's version of the facts set out at the beginning of their factum, and I guess they must have adopted that. But why? Why is that to be preferred over the defense version of the facts? Interesting questions. In any event, we live in a society that has given those powers to the Supreme Court of Canada. They have decided that question in that way. And it's now obvious that the question will be resolved in relation to the news section that's being challenged, that of the false news section. False news. What does that mean? Well, that happens every day. I read it in every newspaper. I guess we're reading it more and more all the time. false news is a crime. Did you know that? Yeah, really. You know, this is, they call it democracy. I wonder if it isn't hypocrisy. I mean, to think that someone could go to jail for publishing false news, it just hits the ordinary person who has any common sense with the greatest wave of revulsion that one could possibly have, if you're thinking. Most people don't have any controversial opinions, so they don't need to worry, and if they did, they'd probably keep them quiet because it's safer, right? Trouble with that is that the other aspect of the minute silence occurs. The minute silence we had at the beginning of this meeting was to demonstrate something. You know what happens during silence? Nothing. Nobody learns anything, nobody says anything, right? Well, you can have a lot of kinds of silence. You can have real silence where people are listening perhaps into their inner heart. Half the time nobody hears anything there anyway. The other kind of silence is absolutely unending noise. You hear it all around you, don't you? Outside on the street, you hear noise. You watch television, you hear nothing but noise. You hear people commenting on the comments of other people who commented on circumstances they knew nothing about. Figure that one out. If you're Irish, you will in a minute. Yeah, you know, I mean, the whole thing about the Gulf War and all that, what do you know about it? What do you really know about it? You hear nothing but noise, and from that you derive emotional responses. That's basically what you're supposed to be. An emotional garbage can to receive the predictable responses that the media says are appropriate. Do you know Saddam Hussein? Do you know what he's done or who he's shot lately? Or, you know, oh yeah, I know it all. I saw it on TV. I used to believe that until I got on TV and realized that, hey, this isn't me. I mean, it's a pack of lies most of the time. Somehow straying off my topic slightly, but not a whole lot. What I was saying was, silence is accomplished when you intimidate and you prevent people who are thinking from saying anything. And it's those people who are thinking that are often dangerous to the powerful when they're deceiving the masses into practices that are destructive, like going to wars that maybe, for example, are not justified or are maybe even not necessary. You don't like people raising difficult questions or putting forward other opinions. And so it's only those few people who dare to think and dare to speak out that ever need to fear from these laws. And it's those very people who are often the most essential to the well-being of all society, because either they ventilate bad ideas and thereby destroy them, or they bring to light good ideas and thereby other people can adopt them. That's how real human development, in my view at least, occurs. And if that isn't the purpose for the marketplace of ideas, if that isn't the purpose for your brain and mine and our tongues and our intelligence, what is the purpose? You know, we eat and we sleep and we reproduce and we die. I mean, is that all there is? Surely God gave us this heart and mind and brains for a purpose. He gave it to us to seek the truth and thereby be set free from whatever lies and delusions we manage to accomplish in or acquire in ourselves, and thereby we become better human beings. So what's wrong with freedom? Well, as I think it's probably true that freedom is dangerous to the powerful who live by corruption. In essence, I was speaking in Austria in October, and it occurred to me that really what we do want, and I think everybody genuinely wants, is peace, both personal and as much as is possible in the world. And I believe that I came closest to a formula for that when I said that without justice, there is no peace. And without truth, there is no justice. And without freedom, there is no truth. So freedom is the essential means to the end of peace. Because from freedom, we can find truth, from truth we can find justice, and if there is justice, there will be peace. But take away freedom, and you will have a monopoly on the ultimate power, which is knowledge. And when people have the monopoly on the ultimate power, which is knowledge, that power corrupts. And that power over knowledge manipulates the masses, the people, into things that are not truth and are not justice, and therefore will not be peace. And the danger of all that, I think any normal, simple, common, intelligent, and as we are all endowed with a certain amount of intelligence, the average person can see. So I'm very concerned about the destruction of freedom of speech. I'm concerned about the cases of Malcolm Ross and Ernst Zundel and John Ross Taylor. For after all, John Ross Taylor's in jail not for promoting hate. And I must correct you, Paul, again. I must apologize for doing so, but he's not accused of promoting hate. The section 13, subsection 1 in the Human Rights Act only requires a discriminatory statement, not a hateful statement, not a false statement, doesn't require an opinion that causes unrest. It is only if you telephonically communicate a discriminatory statement. What does that mean? That is a statement that discriminates or identifies a person on the basis of race, religion, or ethnic origin, and discriminates thereby. He, of course, was ordered not to make telephone calls on his answering machine that identified people whose names he read from the newspaper and what they had done by virtue of their being Jewish. That's what he was accused of. So when he'd served a year in jail, he got out and made some more telephone messages out of newspapers that he read. Well, and once again, I think the only people who ever phoned that number were probably the Human Rights Commission officers who wanted to prosecute him. Nobody else would. There was never demonstrated any effect from what he did. I gravely doubt whether anybody phoned that number other than the various people who swore affidavits for the benefit of the Human Rights Commission who worked for the Human Rights Commission. And thousands of dollars were spent to keep him behind bars or silent. And I can only say that in all probability, when he gets out at the end of his term of imprisonment of a year, at perhaps the age of 81, in my judgment, the first thing he'll do is go to his telephone and his newspaper and record some more messages. So we have this so-called democracy putting him in jail time after time. I suppose they would then deny him bail because he would be very likely to be a repeat offender. Just think about that. Here's a man in his 80s, and he didn't promote hatred. He's not accused of promoting hatred. He didn't say anything false or untrue. He's not accused of false news. He's accused of making a discriminatory statement into his telephone answering machine, and that's it. And they'll put him in jail again if he does it. No question. They've done it before. This is the second time around, and nobody gets upset, you see. I try to stay calm, too, because I think to myself, this is an asylum with the inmates in control. You know, this is really what it is. If anyone had said to me in the 1970s that a person could go to jail for their opinion in 1980, I would have said they were dreaming. And the hate laws say this, and that's all right. I've seen trials which made Franz Kafka look like a kindergarten teacher. In my view, it's all very well to say freedom of speech exists, and then to define it as socially useful, valuable speech and apply your judicial prejudices as if you could shape Canadian society to suit those prejudices. You know, a military dictatorship can be removed, first of all, because it's very obvious that it's there. You know who the military dictator is? He usually comes on television in his uniform and tells you what the greatest thing is in the world, namely him or very seldom herself. Never heard of a female military dictator unless maybe somebody thought it was Margaret Thatcher. Maybe Neil Kinnock thought that. You know, a political dictatorship likewise can be removed by revolution. And these often occur, as you know, in third world countries. But what about a judicial dictatorship where no one knows precisely why the judgment is made that way, because it's so difficult to understand for the average person, so nobody bothers to read it. The judge doesn't appear on television to justify it. It just is. What, is that possible, to have a judicial dictatorship? Would it exist in a country where the rights and freedoms of individuals were defined by individuals who could say what was demonstrably justifiable in a free and democratic society? And is that, in effect, what is happening? These, I think, are intelligent questions that need to be asked and need to be answered. I suppose they're also dangerous questions, particularly for someone who's a lawyer. Maybe we're not supposed to ask these questions. Maybe we're supposed to take the view that whatever the law is always right, and judges who interpret and apply it are always right. If that's the case, then I suppose very unlikely that such a hypothetical judicial dictatorship would ever be changed, because the only people who understood its operation would never be free to criticize it. And I guess that would be just about perfect. That would be as close to perfection and as close to totalitarian as anything George Orwell could ever have dreamed of. And that, in my opinion, is the frightening future prospect in some hypothetical country that, of course, does not exist today. So I think I've given you a certain insight into the concerns I have. They're only my opinions and my concerns. I was asking myself the other day, you can't tell people about a problem without really giving them a solution. It doesn't help them. And I felt rather bad about the fact that what I was going to have to tell people was rather depressing. You know, I don't like to be told a whole bunch of problems. Nobody does. Nobody likes to be told that a situation is disastrous unless somebody says there's a way out of it. And I've been really struggling with the question of whether I should tell anybody anything. Maybe I should never share this anxiety, this despair, this difficulty that I feel with the knowledge that I've acquired. Maybe I should just keep it to myself and let everybody go on in their life without any anxiety. You know, at least I'll be the one who's suffering and I won't spread it around. It's like a cold. I should keep it. Stay home. Go to bed. Maybe it'll go away. It never does. Because the minute you wake up and think about it, there it is. It hits you right in the face and you haven't changed it. So I was saying to Kelty, I wonder, what can I say to these people that will give them some hope? Because I don't want you to be discouraged or depressed. I don't want you to hear me and then go away thinking, God, it's awful. Nothing I can do. But a wiser person said, well, all you can do is tell them the truth as best you know it, and if they're interested, they'll apply their minds to finding a solution. Well, that's maybe naive faith. Maybe most people can't find a solution. Maybe people are looking for leadership, and that was my concern. Can I lead or provide solutions to this problem? Maybe I can, maybe I can't. Here's a few ideas and a few thoughts. First of all, these people who are under attack maybe can benefit, and I know they can benefit, from your moral support, Not that you agree with their opinions. My first concern in meeting James Keekster was not that I agreed or disagreed with his opinions. I didn't even know what his opinions were. My first concern was, I know how the media treat people, and I know when they vilify people like they're doing to you, that it's very, very painful and it's totally unjust. Even if the worst they said about him was true, it wouldn't be justified to vilify him that way, provided, as was the case, that no doubt he honestly believed it. Well, beyond that, I can say that moral support is important for those who are being vilified in the media. And so that's one thing that everybody can do. I mean, you're not necessarily going to be under attack. And hopefully you won't be, because it's absolutely unbearable for these people and their families. So in that sense, you can take your position of concern for freedom of speech into real, genuine, charitable action you can actually communicate with these people and say that you respect their right to their opinion and you don't think they should be deprived of that right. That's, I think, an important first step in coming to the realization that you can't sit back and let somebody else be brutalized, no matter who they are. You know, if somebody was being beaten up by 16 people in the street, I wouldn't have trouble convincing some, hopefully some men and most women in this place. You know, you think of the case in Montreal where all those men stood around and did nothing while the women were shot. You wonder whether men have got any guts anymore. But let's put it this way. I found that most women are willing to fight before most men are for matters of principle. And I don't know why that is. Maybe it's because we've been taught to be too timid too long. But anyway, if you had seen somebody beaten up out in the street there, I believe that a lot of us would go out there and try and do something about it. But we don't do anything about it if the odds in the media are 1,000,000 to 1 against this individual. We kind of think, I don't want that for me. Thank you. It's natural. But maybe it's wrong, just as wrong as it would be to let somebody get beaten to death out in the street. And that's really what you feel like when you've been through the meat grinder of the media. You feel like you've been beaten to death. You feel like you haven't got a friend in the world. And maybe that you don't even deserve one. And that's the worst of it. So, in a way, that's not an unnecessary thing to show just a genuine human concern for another human being. For after all, if they're really wrong in their beliefs, what's the best solution? Isn't it to talk to them and to reason with them and maybe thereby change their view? I guess some people don't think so. They don't believe in reason or persuasion. They believe in the big club. Well, that's up to you. Can you support them in that way? Can you give them financial help? Because I can tell you, for example, in the case of Malcolm Ross, who after all didn't do anything in school to communicate his beliefs, he only did this. He published books, 3 of them, on his own time, which he sold privately, that expressed his beliefs about the world, his view of the world, his view against abortion, his view about an international Zionist conspiracy. Okay, big deal. If there is one, why shouldn't you talk about it? If there isn't one, why isn't it science fiction? So what are they doing? They're trying to destroy that man through taking his job, his employment. He's about my age. Did you know that there's a number of anomalies in life, things that really are strange, maybe little personal anecdotes are not out of place? It turns out that he and I were born in the same hospital in the same city at the same time. We were in the same nursery. So you know how old he was. He was born May the 1st, I was born April 24th. But in those days, they used to keep women and their babies in the hospital for 2 weeks, so we were in the same nursery at the same time in the same hospital in the same city. So you know how old he is. He's got 4 little kiddies and children. I shouldn't say kiddies, that's outdated, isn't it? And he has a lovely wife who's a nurse. And I must say, she's a very courageous lady. She stands by him. She's French-Canadian, or I should say Acadian. So, you know, they have a tough time painting this guy as a bigot, which they usually is the first step. Bigot, racist, white supremacist, or some other horrendous label that they basically crucify you with before your trial. But they've done an enormous campaign against him. The cabinet ministers condemn him. The premier of New Brunswick condemns him. Okay, now let's try him. Looks like we've got the people warmed up for him. But it hasn't worked. It hasn't worked probably because he's a very, very dedicated and sincere Christian. I mean, he really has faith. And I think at times he has a whale of a lot more faith than I do about people and about the system. But he's behaved himself with real courage and patience and understanding. He's never responded to these attacks. Now, you know, at times he's been tempted, and once he went on television, and of course that became the subject of another complaint, you know, is the minute the public can see these people as they are rather than as they're painted, it's as if you'd struck a sensitive nerve. And automatically there's an enormous new attack. God help us if we ever allow these people to be seen as they are. That's one of the things I've always felt most unfair about this whole process of thought control, speech control, condemnation in the media. It's never what the person says, it's what somebody says they said. You know, I mean, half the things we say about these people, from my own experience, it comes through the media secondhand, more than half, all of it for most people. And this distortion is entirely unfair. But in the case of Malcolm Ross, he's faced with enormous costs, and on his salary as a teacher, no one else is helping him. We have in that hearing the Department of Education paid for with public funds, the New Brunswick Teachers Federation paid for with collective funds from all the teachers in New Brunswick, the school board paid for with tax funds, the Human Rights Commissioner appearing paid for with tax funds. At one time the Minister of Labour was even appearing, also at taxpayers' expense. And it drags out for days and days and days, because it's like all, you know, proving the history of the world practically. And they just grind him down, and he's paying every penny of his own costs. You know, just imagine what that means. He's got a wife and 4 kids, and he's the only one in that room who isn't on the payroll from the government. Now, if that isn't unjust, what the hell is unjust? Well, it just appalls me, and I guess it's only because people are scared that they don't really come out. You know, he tells me they whisper to him in the supermarket, "We think you're really good. Keep up the good work. We admire you. We're behind you." Yeah, you bet. Way behind me. You know, that situation is very human, very real. Courageous people throughout history, I guess, have always had to face their particular struggle alone. But it need not be so, and your assistance, your encouragement, your support to these people will preserve your freedom as well as theirs. And that's why your presence here today is important, very, very important to me, because at least it shows that there are some people who care enough about freedom of speech to take some time on a Saturday afternoon and a cold day to think about it and to hear somebody else talk about it. That means a lot to me. It means a very great deal to me that you're here, because if you weren't, why would I be here? And if we can work together to support each other in this struggle for freedom and support those particularly who are under attack, then maybe I have come up with a bit of a solution for you. Maybe I can give you an element of hope. It doesn't come from me, but it can come from you. If there is any hope, it's that I can carry on to do what I'm trying to do, but furthermore that you can help. And all I can promise you is that I will keep trying to the best of my ability as long as I can. But each of you is far more important, because it would be as significant for me to keep trying in what I'm doing without your help as it would for me to stand in this room to a bunch of empty chairs. So you see just how important you are. And that's always been the way it is, you know. History has not been made by great masses of people instantly coming to a realization of the truth. History has always depended on a few courageous individuals who stood against the tide of ignorance in history, who dared to stand for their principles and fight for them, and who did not and would not surrender to what they knew to be wrong. So if that spirit of dedication, that spirit of love of truth, that spirit of honor and dignity exists in us, then there still is hope. And that's all there's ever been. This is not going to be a struggle that'll end tomorrow in the Supreme Court of Canada or end anywhere. It'll be a struggle that'll go on long after I'm dead, but the part that you and I play in it will be our contribution to history and our testimony to whatever God we believe in, that we took seriously the dignity that He gave us in creating us. Thank you very much.